Hey everyone, welcome back to my YouTube channel. This is Renito Arthur, aka The Light Lawyer. Today I'm discussing the jurisdiction of courts. In particular, I will tackle the hierarchy of courts. Which court it's the highest in hierarchy, and which one is low in hierarchy. So today, basically, I'm going to start with Article 126 of the 1995 Constitution, which provides that justice shall be exercised by the courts established by the Constitution. So in this article, this very Constitution, the 1995 Constitution, it's the one that establishes the existence of courts. So in the same provision, in the same article 126, also provides that justice shall be done to all, meaning that there shouldn't be any discrimination regardless of sex, gender, and so whatever. So basically meaning that justice is for all, equality in justice. Then the same article, it talks about justice shall not be delayed. So I want you to mark the key aspects that are in this article. This article, it provides that justice shall be done to all, justice shall not delay, adequate compensation to the aggrieved parties, and also reconciliation of the parties. So basically, these are some of the importance, some of the mandates of the courts. So the courts will make sure that the aggrieved party shall be compensated. The courts shall make sure that justice is not delayed. The courts shall make sure that justice is given to all without any discrimination in regards to sex, age, gender, or your how you're called in public. No. Justice is for all. That's equality. So, if I may proceed, there is an interesting article. That's Article 128 of the 1995 Constitution. Article 128 of the 1995 Constitution, it provides that no person or authority shall interfere with the decisions of the courts or judicial officers while exercising their functions. So Article 128, it provides for the independence of the judiciary. Remember, we have three arms of government. We have the executive, the judiciary, and the legislature. The executive is headed by the president. The judiciary is headed by the chief justice. And the legislature is headed by the speaker. So these three arms of government should be independent. So this article, Article 128, it provides for the independence of the judiciary. According to Article 129 of the 1995 Constitution, it provides that the courts of judicature of Uganda, for example, the Supreme Court, the Court of Appeal, the High Court, and other subordinate courts as established by Parliament. So this Article 129, it provides for those courts of judicature. And also, Clause 3, it provides that the Parliament can make laws providing for the jurisdiction of courts. And through this, the Parliament enacted the Judicature Act. And so this Judicature Act, it provides for various courts applicable within Uganda. And these courts include, we have the Supreme Court, we have the Court of Appeal, we have the High Court, and other subordinate courts. And also, it was on that clause 3 of Article 129, that the Parliament also enacted the Magistrate Courts Act. This Magistrate Courts Act, it was basically for the subordinate courts. That's the magistrate grade 1, grade 2, the chief magistrate courts. They derive their mandate from the Magistrate Courts Act. So the Parliament has the role of establishing laws that will help in the running of various courts. So let me give a brief summary of the hierarchy of courts. Number one, we have the Supreme Court. We have the Court of Appeal that sits as the Constitutional Court. We have the High Court. We have the Chief Magistrate Court. We have the Magistrate Court Grade 1. We have the Magistrate Court Grade 2. So that's the hierarchy of courts, and we are going to look at each court one by one, and we are going to start with the Supreme Court since it's the highest in hierarchy. The Supreme Court, it's established in Article 130 of the 1995 of the Constitution, and when you read under Article 131, it provides for the composition whereby the Chief Justice is the head of the Supreme Court. Then we have Article 132 of the 1995 Constitution. It provides that the Supreme Court shall be the final appeal court, and its decisions are binding to all other courts. So this provision or this article means that if at all the Supreme Court makes a judgment, that judgment or that decision, it must be bound or must be followed by all these other courts, including the Court of Appeal, the High Court. All those courts, they have to abide by the decision of the Supreme Court. And we also have Article 104 of the 1995 Constitution. This one, it provides that the Supreme Court shall have original jurisdiction with regards to the petition of the elections of the presidents. For example, just as we've concluded this election, one of the contestants can petition to the Supreme Court in regards to these presidential elections. For example, we have a lot of cases like Chiza Besigye versus Yoweri Kaguta Museveni election petition 2006. We also have other cases regarding, but all this, the Supreme Court is the only court that handles presidential election petitions. So it has original jurisdiction in that, in regards to that issue. And the second one, we're having the Court of Appeal. The Court of Appeal can sit as the Constitutional Court. According to Article 134 of the 1995 Constitution, it provides for the establishment of the Court of Appeal. And according to Article 135 of the 1995 Constitution, it provides for the composition of the Court of Appeal, whereby for it it's headed by the Deputy Chief Justice. According to Section 137 of the 1995 Constitution, it provides that the Court of Appeal shall sit as the Constitutional Court, meaning that it has the power to interpret laws. It has the power, if at all the Parliament, remember the Parliament has the mandate of making laws, but the courts, as the Constitutional Court, has the power to interpret these laws. And if at all the laws made by the Parliament are found to be inconsistent with the 1995 Constitution, the Court of Appeal, sitting as the Constitutional Court, can make such laws as void. Remember, according to Article 2 of the 1995 Constitution, it provides for the supremacy of the Constitution, meaning that all other laws must be in line with the Constitution. So meaning that if the laws the Parliament have made are inconsistent with the Constitution, they are automatically null and void. So basically, the sole purpose for interpretation of these laws, it's derived in the Constitutional Court. So according to Article 138 of the 1995 Constitution, it provides for the establishment of the High Court. And according to Article 139 of the 1995 Constitution, it provides for the jurisdiction of the High Court, and it provides that the High Court has unlimited original jurisdiction in all matters, and such appellant and other jurisdiction as the Constitution has mandated it to do. For example, this High Court has unlimited jurisdiction. At the same time, the Constitution can mandate the High Court to do or to entertain some cases, and also it receives appeals from the lower or subordinate courts, for example, the Chief Magistrate Courts, the Magistrate Grade 1, and etc. So that's basically the jurisdiction of the High Court. Then, and another thing is the Chief Magistrate Courts. We have also the Magistrate Court Grade 1 and Grade 2. These magistrate courts, they derive their mandate and authority in the Magistrate Courts Act. That's where they derive their mandate from. But I want you to be very keen. There is what we call territorial jurisdiction and pecuniary jurisdiction. Territorial jurisdiction, this simply means that a court can only entertain matters within its jurisdiction or within its territories. So if at all a case was committed and this case was committed not in the court's jurisdiction, then that court does not have the power to entertain those matters. But if at all that person has committed an offense in the court's jurisdiction or territory, then that court has the power to try him within its territory. Then pecuniary jurisdiction. Pecuniary jurisdiction, this simply means the money, the monetary value. So these courts, they have what we call the pecuniary jurisdiction. This can, in the other way, mean the limitation that they can handle. For example, magistrate court grade 1 cannot entertain cases of 20 million and beyond, meaning that it only entertains cases of 20 million and below. That's its pecuniary jurisdiction. Are you seeing? Then we have the Chief Magistrate Court. The Chief Magistrate Court entertains cases of pecuniary interest of only 50 million shillings and below. Are you seeing? So meaning that if at all there is a case of land and this land is valued at 100 Uganda shillings, 100 million Uganda shillings, then this case is taken to the High Court because the High Court has unlimited jurisdiction. Which take it has unlimited original jurisdiction, but the Chief Magistrate only allows 50 million and below. So that's the thing I want you guys to understand. Territorial jurisdiction and pecuniary jurisdiction. To further expound more on territorial jurisdiction, if at all, let me say, X commits a crime in Kampala and is taken in a court in Entebbe, that High Court or that Chief Magistrate Court in Entebbe will not entertain his case, reason being he did not commit that crime or the offense in its territory or jurisdiction. That person will be tried in the High Court or the Chief Magistrate Court of Kampala, not Entebbe. So that's basically about territorial jurisdiction. So in regards to the hierarchy of courts, we have the Supreme Court as the highest, the Court of Appeal that sits as the Constitutional Court. We're having the High Court, we're having the Chief Magistrate Court, we're having the Magistrate Court Grade 1 and Grade 2. Though, however, the Magistrate Grade 2, right now, they are ceasing to exist. They are trying to remove them because Magistrate Court Grade 2, the people, they are not lawyers. They are people who just based on equity, the principles of equity and the fairness to rule out cases. And their pecuniary interest is 500 and below, 500 Uganda shillings and below. Are you seeing? So right now they are trying to seize out, but so far the Magistrate Court Grade 1, they are active because for them lawyers are the ones operating. So as they are operating, they are using common law, the principles of equity, and also they are using the statutes, the laws. So basically that's the end of this tutorial, and in case you find this session interesting and productive, kindly please like, subscribe, so that you do not miss out for more videos. Thank you very much.